Thank you. Your Excellencies, ladies and gentlemen, dear colleagues, welcome to this panel discussion on failure to protect the International Criminal Court hosted by the Rights Forum. I am Giulia Pinzauti, and I'm an assistant professor of public international law at Leiden University. I work on international criminal law and legal issues related to the situation in Palestine, amongst others. So I'm grateful to the Rights Forum for organizing this event. It is an important discussion to have, especially in the Netherlands, and we are at a critical moment. The Rights Forum is an organization founded on respect for international law and human rights, and it's a completely donor-based organization. So we wish to thank all the donors for making this event possible. And thank you for being here, for taking time out of your busy lives to be here tonight. And special thanks in particular to members of the diplomatic community and the court officials that are with us tonight. Finally, I wish to inform you that this event is being recorded, but only what is being said from the stage, so the public will not be filmed. And with that, we've dealt with all housekeeping matters, and we can get to the substance. What brings us here tonight is an unprecedented attack against the independence and impartiality of the International Criminal Court, a permanent court that was established to try those responsible for the most serious crimes under international law: genocide, war crimes, crimes against humanity, and aggression. The court, as you know, has its seat here in The Hague. In February last year, President Trump issued an executive order imposing sanctions on the ICC. Since then, US sanctions have targeted 11 court officials, the prosecutor, the deputy prosecutors, and 8 judges. To give you an idea, that's nearly half of the entire bench. They've also targeted a UN special rapporteur and 3 Palestinian human rights organizations, whereas a 4th organization was targeted under a different scheme. These sanctions have wide-ranging effects. Sanctioned individuals have had their bank accounts blocked, their assets in the US frozen, and they and their family members are banned from entering the US. In addition to this, the executive order has criminalized the provision of assistance or services to sanctioned individuals. So US persons, including US nationals, but also US private companies, think of Microsoft, Meta, Amazon, just to mention some, who do not comply with the executive order face penalties of up to $1 million in fines and 20 years imprisonment. And now the whole court faces the threat of institutional sanctions. And on behalf of the Rights Forum, I wish to express our solidarity to all those that have been sanctioned and continue their work on accountability undeterred. I think it's useful to recall that sanctions are coercive acts that are typically used in the fight against organized crime, such as drug trafficking or terrorism. Here, there is no crime. Simply, people are being punished for their work on accountability against US and Israel's interests. It's shocking to see how sanctions have been instrumentalized to put pressure on a judicial institution and those working on accountability. But these sanctions are not an isolated policy. They are only the most forceful step in a long-running strategy to prevent or undermine ICC investigations involving the US or Israel, and especially the court's work on Palestine. The US is not a party to the Rome Statute, the founding treaty of the International Criminal Court, and neither is Israel. Both states have consistently opposed the court's jurisdiction over their nationals. But the Rome Statute is clear that the court has jurisdiction whenever alleged crimes are committed on the territory of a state party, such as Afghanistan or Palestine, even when by nationals of non-party states. This is what states have agreed when establishing the ICC, so there is really no US or Israel's exception to the jurisdiction of the ICC. That's also why all legal challenges to the court's jurisdiction related to the situation in Palestine have failed thus far. And probably is why the strategy of those opposing the ICC has shifted from criticism to coercive measures to bend the court's arm, including spying, interference, threats, intimidation, and then the sanctions. Ladies and gentlemen, a red line has been crossed. Any attack on the independence and impartiality of a court is an attack on the very foundations on which our democratic societies are founded. Of course, we have no control over the conduct of foreign states, and it's easy to feel powerless. But we do have control over how we respond. And this brings me to the central theme of today's discussion. The Netherlands is the host state of the International Criminal Court and has the responsibility to, I'm quoting from the headquarters agreement, take effective and adequate action to ensure the security, safety, and protection of persons indispensable for the proper functioning of the court, free from interference of any kind. End of quote. Threats and intimidations have taken place here on Dutch soil. So how has the Netherlands responded? And perhaps more importantly, how should it respond? To explore these questions, we have an outstanding lineup of speakers tonight, comprising former ICC prosecutor Fatou Bensouda, a representative of Al-Haq, Ahmed Aboufou, and MP Suzanne Kroger of Progressive Netherlands. Please join me in welcoming them on stage with a warm round of applause. Our keynote speaker for tonight does not need an introduction. Her Excellency Bensouda led the Office of the Prosecutor of the International Criminal Court between 2015 and 2021. During her tenure, the office opened an investigation into the conduct of US forces in Afghanistan and into alleged crimes committed in Palestine by all parties to the conflict. She and her family were subjected to threats and intimidation, and in 2020, she was the first ever court official to be sanctioned by President Trump during his first term in office. Your Excellency, it's an honor to have you with us tonight. The floor is yours.
Thank you very much for your kind introduction. Distinguished colleagues, excellencies, members of the diplomatic community, representatives of civil society, scholars, practitioners, and friends of international justice. I am grateful to the organizers for their kind invitation and for convening this evening's timely discussions. We meet at a difficult moment for international legal order. The International Criminal Court, a key pillar of the international rule of law, was created not as an instrument of politics, but as a necessary institution of law. It was established through the sovereign consent of state parties under the Rome Statute to ensure that the gravest crimes known to humanity, genocide, crimes against humanity, war crimes, and the crime of aggression, would not go unanswered merely because they were politically inconvenient to prosecute, or that the perpetrators are powerful and hence untouchable. The work of the court was never intended to be easy. It was designed, at least in theory, to operate precisely where political pressure may be strongest, where accountability is resisted, and where powerful actors may prefer silence, inaction, or shielding over legal scrutiny. And that is why sanctions directed against the court, its officials, and those who support its mandate, including civil society, are so deeply inappropriate. These measures are not merely a disagreement with legal outcomes. They are coercive attempts to interfere with the independent exercise of judicial and prosecutorial functions established under international law. If the international community does not respond with seriousness, institutional resolve, and practical solidarity, the consequences will extend far beyond The Hague. We are already seeing the corrosive impact of inaction play itself out in the unchecked level of violence unleashed in Gaza and in other conflicts around the world. So the issue before us today is not whether every state agrees with every decision of the court. Reasonable legal disagreement exists in every judicial system. It is accepted that some of the court's legal work may be politically uncomfortable or inconvenient for certain state parties, and even more so for non-state parties that are affected by its jurisdiction. But international criminal justice is not a selective tool to reflect the preference of some while overlooking other situations that require judicial scrutiny. To remain credible and effective, it must be pursued seriously, guided by ethical leadership and applied consistently, on principle, and without fear or favor. If that principle is abandoned, when the integrity of international adjudication itself is placed at risk. The issue is whether independent judicial institutions may be subjected to economic coercion, intimidation, and personal retaliation for carrying out mandates lawfully conferred upon them. Today, I want to make 5 principal arguments. First, that sanctions against the ICC are fundamentally incompatible with the rule of law and judicial independence. Second, that my own experience, my own personal experience, demonstrates that both the human cost and the necessary sacrifice and ethical resolve involved in resisting such pressure. And third, that state parties and stakeholders in the Rome Statute system must move beyond rhetorical support and adopt concrete institutional protections without delay. And fourth, that the international community must prepare now for the possible escalation, including institutional sanctions against the court itself. And fifth, that these coercive measures ultimately constitute an abuse of sanctions policy, one that is ineffective, unsustainable, and damaging even to the credibility of those who employ them. So let me begin with the first principles. The ICC is not an activist organization. It is not a political movement. It is not a geopolitical rival. It is a treaty-based judicial institution with critically important mandate. Its prosecutors deputy prosecutor, and judges are elected by state parties. Its staff are dedicated international civil servants who work tirelessly to uphold the court's founding principles and deliver a measure of justice to victims of atrocity crimes. Its procedures are governed by law, and its jurisdiction is constrained by treaty provisions, admissibility rules, complementarity requirements, and judicial oversight. One may contest jurisdictional interpretation. One may debate prosecutorial discretion, and one may criticize investigative strategies. But sanctions are something entirely different. Sanctions are instruments traditionally justified as tools to counter threats such as terrorism, corruption, proliferation, transnational criminality, or serious human rights abuses, and to deploy such instruments against prosecutors, judges, or court officials who are engaged in judicial functions in the pursuit of accountability for the most egregious crimes represents a profound conceptual distortion. It is thuggish and inappropriate, and it should be called out for what it is. It transforms disagreement with legal process into crippling economic coercion to meet political ends. It is bullying, coercion, and power politics through other means. It sends a chilling message, not only to the ICC, but to any international judicial institution whose work may become politically inconvenient. And these attacks on the court must also be understood within a wider deterioration of the international legal order itself. Around the world, we are witnessing growing pressure on the institutions, on treaties, and on norms created in the aftermath of the Second World War to constrain raw power with law. As I recently warned in an op-ed published in Al Jazeera, the international system risks drifting towards a force-based order, one in which might displaces rights and power eclipses principle. That warning should concern every state represented here today, particularly the smaller and middle powers whose security ultimately depends not only on hard power and alliances, but on the predictability and integrity of international law. We must be very clear about the implications. If international civil servants may be targeted for implementing treaty obligations, what protection remains for institutional independence? What would be left of the institution? What value is left for it to offer to the world? If states normalize retaliation against judicial actors through inaction, appeasement, or collusion, then the principle of impartial accountability becomes a hollow slogan and contingent on selective political acceptability. This is not the rule of law. This is not justice. That is conditional legality tainted by the machination of selective politics. And conditional legality is incompatible with the very idea of equal justice. In short, it is a mockery of international justice, an outcome we must not accept. I served as ICC prosecutor during one of the most politically difficult periods in the court's history. As is publicly reported, I became the target of personal sanctions and restrictions, not because I committed misconduct or corruption or abuse, but quite on the contrary, because for the first time in the history of the organization, supported by my able colleagues at the ICC Office of the Prosecutor, we demonstrated that the court's work matters and that it will do its job whenever the law requires it and without fear or favor. That was evidently the original sin in the eyes of some. In addition to sanctions, a travel ban, and public attacks by some of the most powerful political actors, I have reason to believe that the same forces behind those overt, coercive measures may also have affected my career trajectory after leaving the ICC. If this is the price of integrity, courage, and sincere dedication to the plight of victims of atrocity crimes without distinction, then so be it. As you can see, the consequences of ethical and consistent application of international law are not abstract. Sanctions regimes affect banking access, travel, financial services, including wiring funds to family members, professional interactions, insurance, relationships, contractual arrangements, and reputational standing. They create uncertainty not only for the individual targeted, but again for family members, institutions, service providers, and professional networks. And the purpose of personal sanctions is not merely punitive. It is deterrent. It is intended to create fear. It is intended to isolate. It is intended to signal to others that if you pursue certain lines of inquiry, if you dare to be just when it doesn't pay for some, you too may face consequences. And yet I, supported by my able team, many of whom are present today, we continued. We continued to exercise our responsibilities with seriousness and with resolve. And we did so with dignity. We did so with restraint. We did so with professionalism and seriousness. And we did so notwithstanding all sorts of threats and pressure tactics, including by inappropriate reach out from politicians and head of intelligence agencies, and all were aimed at derailing our work. And we did so largely feeling alone and insufficiently supported, including by states, the court states parties, and their largely slow and timid reactions, inactions, and empty gestures of support without tangible backing and pushback against these coercive measures. And perhaps, just as importantly, we did so without allowing the ICC Office of the Prosecutor to become consumed by political confrontation. And that matters. Because institutional courage is not measured only by defiance. It is also measured by discipline adherence to legal principle under extraordinary pressure. And I hope that our example reminds us that the cost of these sanctions and the tactics are borne not by abstract institutions, but by real individuals, lawyers, investigators, civil servants, experts, people with families, people whose careers and personal lives can be disrupted simply because they chose to serve international justice. And we should ask ourselves an uncomfortable question. If highly qualified professionals conclude that service at the ICC carries unacceptable personal and financial risks, what happens to the future capacity of the institution? What happens when sanctions become normalized as tools of judicial intimidation? What happens when banks decline services, insurers withdraw coverage, technology providers hesitate to engage, and external experts fear association with the court? And this is not hypothetical. The secondary and tertiary effects of sanctions architecture are often broader than the formal legal measures themselves. Overcompliance becomes endemic. Private actors withdraw preemptively, and institutions self-censor to become overburdened by mitigating measures adversely impacting operational effectiveness. Professional ecosystems become fragile, and this is precisely why states parties cannot respond merely with expressions of concern. The Rome Statute system now requires structural resistance. Supportive statements are no longer enough. Concrete proposals are necessary. First, states parties largely failed to demonstrate a strong and effective response to when I was sanctioned and my other colleagues were threatened privately and publicly. State parties, through the Assembly of States Parties, should establish coordinated legal defense and indemnification mechanisms for sanctions court officials and staff. There must be coordinated and strong démarches protesting such coercive measures, especially if institutional sanctions are being imposed. No prosecutor, judge, registrar, or investigator acting within lawful mandate should face personal financial ruin because of politically motivated sanctions. Second, states should create protected banking and financial channels for the court, the personnel, and authorized contractors. The European Union should move to trigger the EU Blocking Statute and share with the court any tangible gains it may have achieved with respect to tech autonomy initiatives. One of the most powerful aspects of modern sanctions regime is not formal prohibition, but financial exclusion. If the international community is serious about preserving judicial independence, then practical continuity mechanisms must exist. Third, state parties should adopt domestic legislative safeguards preventing enforcement cooperation with coercive measures directed against lawful ICC activity. And national implementation matters. The Rome Statute system cannot depend solely on moral solidarity. It requires operational solidarity. Fourth, contingency planning must become institutionalized. The Assembly of State Parties should support the court in emergency continuity frameworks for scenarios involving institutional sanctions against the court itself by assisting it where it may require support. From my own experience managing the office at the time the first sanctions were imposed, these could include digital infrastructure resilience, securing payment systems, insurance arrangements, staff mobility protection, secure communications, procurement continuity, and emergency host state coordination. The time to prepare for escalation is before escalation occurs. Fifth, universities, the bar associations, civil society organizations, philanthropic institutions, and professional networks must deepen their support. The defense of international justice cannot be outsourced solely to diplomats. The wider international justice community must recognize that attacks on the ICC set precedents that could eventually affect other tribunals, investigative bodies, multilateral institutions, and work of civil society actors. Civil society has been the most vocal on this issue, but its efforts could be better coordinated and more forceful publicly. And sixth, state parties should consider the establishment of a standing sanctions response coordination mechanism within the Rome Statute framework. Such a mechanism should monitor coercive measures, provide rapid institutional support, coordinate counter-response strategies, engage affected private sector actors, and facilitate collective diplomatic responses. Fragmented reactions benefit those who are applying pressure, and coordination creates resilience. And let us be candid. The possibility of future institutional sanctions is no longer unthinkable. It is being openly flaunted. If institutional sanctions were imposed directly against the court, affecting technology access, banking systems, travel or cooperation arrangements, the operational consequences could be severe. But the broader consequences could even be more severe, because such sanctions would represent a direct challenge to the autonomy of a multilateral judicial institution established by sovereign states. At that point, the issue would transcend the ICC. It would become a test of whether treaty-based institutions can function independently when their work implicates powerful interests. And that is why preparation is not an alarmism. Preparation is governance. And no responsible institution waits for a crisis before developing continuity plans. And importantly, preparation itself may help deter escalation. Institutions perceived as isolated are vulnerable, but institutions that are backed by coordinated and publicly present networks of state and civil support are harder to intimidate. Now, some will argue that sanctions are simply another tool of statecraft. But this argument, I believe, ignores the unique nature of the target. The ICC is not a hostile government. It is not an armed group. It is not a terrorist organization. It is not a sanctions evader. It is a critical judicial body. And using sanctions against judicial actors represents a dangerous misuse of a tool originally justified for fundamentally different purposes. There is a deeper problem here. Over the last 2 decades, sanctions have expanded dramatically in scope, in frequency, and in normalization. They have become instruments not only of national security policy, but increasingly of political signaling. Yet sanctions regime derive legitimacy in part from the perception that they are used in response to exceptional threats. When sanctions are deployed against prosecutors and judges for performing legal functions, that legitimacy erodes. The distinction between accountability measures and political coercion becomes blurred. And once that distinction collapses, the credibility of sanctions policy itself suffers. Indeed, one of the long-term risks for the authors of these sanctions is reputational and credibility. States that traditionally champion judicial independence, rule of law, and institutional integrity cannot indefinitely reconcile those commitments with punitive measures directed at international legal actors. The contradiction becomes increasingly visible, particularly to the global South, particularly to states that already perceive inconsistency in the international legal order, particularly to younger generations of lawyers and diplomats, and indeed, an ever-aware global population observing how principles are applied selectively. Reputational capital is not inexhaustible, and credibility in international law depends heavily on consistency. One cannot persuasively defend judicial independence domestically while you're undermining it internationally. Nor should anyone assume that these measures are cost-free diplomatically. Many states may remain cautious publicly, but concerns about the precedent are widespread. Because of if sanctions against international judicial officers become normalized today, similar tools may be used tomorrow against investigators, against rapporteurs, arbitrators, against treaty bodies, or regional courts, in fact, against anyone. And the architecture of multilateral governance depends significantly on institutional independence. Once coercive retaliation becomes accepted, the entire ecosystem becomes more fragile. There is also the practical question of effectiveness. And let us just ask some obvious questions. Have these measures succeeded in ending the court's work? No. Have they eliminated investigations, prosecutions, and the issuance of arrest warrants? No. Have they delegitimized the Rome Statute system globally? I would say no. If anything, they have generated a renewed debate about the necessity of insulating international justice institutions from political pressure. They have reinforced awareness of the vulnerabilities embedded within global governance structures. And they have prompted many states and observers to recognize more clearly the importance of institutional resilience. And this is often the paradox of coercive pressure. It may create short-term disruption, but over time, it can strengthen the determination of institutions and stakeholders to reduce dependency and build protective mechanisms. Moreover, coercive measures against judicial institutions face a structural limitation. Courts derive legitimacy not from military power or economic leverage, but from normative authority. And you can sanction officials, you can restrict travel, you can complicate financing, but it is far more difficult to extinguish the underlying principle that the grave crimes require impartial accountability. And that principle has survived wars, political backlash, non-cooperation, and it has survived decades of skepticism. And it will survive sanctions. But survival alone is not enough. The objective should not merely be endurance. It should be institutional strengthening. And this moment, therefore, requires strategic seriousness from all supporters of the Rome Statute system. State parties must invest politically, legally, and financially in the court's resilience. Civil society must sustain public legitimacy. Academia must continue rigorous defense of judicial independence. And private sector actors must resist reflexive overcompliance that undermines lawful institutional functioning. An international organization should recognize that attacks on one multilateral legal institution may eventually affect others. And above all, we must reject the normalization of intimidation as an acceptable response to legal scrutiny. International justice cannot function if prosecutors calculate political risk before legal merit. Judges cannot operate independently if financial retaliation hovers every consequential decision. And victims cannot place trust in international accountability mechanisms if powerful actors may simply punish institutions for doing their jobs. And this is not merely about one court. It is about whether law retains any autonomous space in international affairs. It is about whether treaty commitments remain meaningful when politically inconvenient. It is about whether judicial independence applies universally or selectively. And history will remember how the international community responded. History will remember whether states, parties, defended the institutions they created. History will remember whether legal principle was upheld consistently. It will remember whether intimidation succeeded. And it will remember who was genuine and who pretended, who colluded, who opted for willful blindness, and who showed courage and principle when it counted most. The Rome Statute system was built on the understanding that accountability for atrocity crimes must not depend entirely on political convenience. That aspiration was ambitious when the court was founded. It remains ambitious today. But institutions are tested precisely in moments of pressure. And the response to sanctions against the ICC will reveal much about the durability of the international legal order. The response and the proper response to coercion against judicial independence is not hesitation. It is collective resolve. Not rhetorical solidarity, but operational solidarity. Not temporal outrage, but durable institutional protection. Because If international justice is worth building, it is worth defending. What is ultimately being tested is whether the international community still believes, or in effect, ever really believed that law should restrain unchecked and illegal exercise of power. The post-war legal order was imperfect, but it represented one of humanity's most important civilizational achievements, and that is the attempt to replace coercion with rules, impunity with accountability, and violence with legal constraint. If that system is allowed to erode through intimidation, through selective legality, and political expedience, the consequences will not be confined to The Hague. The result will be a more volatile world, a more fragile multilateral system, and a more dangerous international environment, and for all states. The defense of international law requires courage, especially when politically inconvenient, when it's personally costly, or opposed by powerful actors. In closing, allow me to say a few words about ethical leadership against the background of our discussions. Ethical leadership is essential to the credibility, the effectiveness, and the longevity of international criminal justice mechanisms. International accountability mechanisms must be led by people who are committed to their mandate, not to self-interest. Leadership must be grounded in values, in ethics, and a genuine devotion to justice. True leadership demands judgment. It demands restraint and tact. It requires placing the integrity and the mission of the organization before one's own position, especially when affected communities, victims, and millions around the world look to that institution as a final bastion of justice. Leaders of accountability mechanisms must never trade institutional integrity for political convenience or for short-term gain. Their legitimacy depends on independence, on the respect for the separation of powers, and the principled relation with member states. When political calculation overrides judicial independence, the mission of international justice is compromised. Leaders of such vital institutions must uphold the highest standards of ethics and good governance so that they remain beyond reproach and, through principled leadership, not only advance their mandates, but also they strengthen the credibility of the organization they represent. Any lesser standard weakens international criminal justice and the wider cause of peace and security that accountability is meant to protect. Ladies and gentlemen, thank you. Thank you for your patience, for patiently listening to me. If judicial independence is truly a principle of the international order, it must be defended even when politically inconvenient. By steadfastly defending international law and the institutions that uphold it, we do more than preserve norms. We help shape a more just world, and we uphold humanity's enduring promise. I thank you.
Thank you. Thank you very much for this account of the importance of judicial independence and also the human cost of sanctions, their illegality, and also the steps that should be taken to limit their effects. But I was wondering, once the sanctions hit someone like you, a prosecutor or a judge, what do you do? Is there anything that you can do as a non-US national, any avenue for a course?
Well, going from what happened, the example, I think immediately what we, of course, it was very disheartening to see that for doing your legitimate work, you are being sanctioned for that. But my team rose, the ICC, the team within the office, but also the registry. We rose to see together what could be done to address this situation, because it directly impacts on the work of the office, on my leadership as the ICC. What could we do? I mean, there are certain things which perhaps is not convenient to discuss openly here, but of course we also reached out to the host state to see what can be done. We reached out to the state parties to see what they could do to assist, because as I said, it directly impacted my work to the extent of I was not even able to task certain nationalities because it would directly affect them even criminally. So, but we worked on it. It did not stop the ICC from working, which was very important. It did not stop us from taking care of the other cases which were also still pending. And we were actually able to achieve quite a lot in different cases. I think during that period, we were able to make, I think, three arrests across 3 continents. And I think also in the middle of COVID. So I'm saying, giving these examples to show that work has to continue. We cannot receive the sanctions and then it's hands down, or what can we do, how can we address this? We had to get up and together with the team, work together to see what could be addressed internally, but also externally, and how could we confront what has happened to the court? How can work continue without just being severely stopped or halted by the sanctions that had just landed?
You were also the victim of threats and intimidation. What was the response of Dutch authorities in that case? It's unfortunate, but I think the Dutch response was quite muted. I don't think anything was done, at least not to my knowledge, because this is a matter that was that did not just stop at the ICC. We escalated it to the Dutch authorities. I remember I personally went to the Dutch authorities. The registry was there, my staff. We went together. This was reported. But as far as I know, apart from the fact that we were assisted in the financial aspect of it, the banks that the ICC was banking with, at least we were able to receive our salary and things like that. But apart from that, I am not aware of anything else that was done, especially the personal security that I saw for my family, for my staff, for myself. In that regard, nothing was done, at least as far as I know. So just to be clear, you had people coming to your home in The Hague to deliver strange parcels and messages, and nothing was done? There
was a particular incident which happened during the time I was there, in which some people pretended to come and deliver a message to me. And also to thank me for some work I supposedly did for a woman who, I don't know, someone who lived elsewhere. And this was reported, and I was given an envelope that the woman wants to thank me. But the insignificance of the amount that was given to me, I mean, I think at least they could have given more, but... So, It was a message. It was a message to let me know that we know where you are.
Of course.
We know where you live. That was it. And of course, that is how I understood it. And immediately I reported this matter again to my office, my staff, the senior, we reported it to the senior members of the staff, and we got together, and this was reported to the registry. It was also escalated again to the Dutch government. And I think the feedback that we eventually received, because it took a long time to know that those people who came to my home did not live here, that the car that they were driving was a rented vehicle for that morning, and various other things which perhaps it will not be suitable to discuss them here. But at least that is the feedback we got. But as far as I know, nothing further was done. So this was just there.
Well, I hope things are different now, sincerely hope so. Thank you very much. I'm sure we'll come back to some of these issues later. So if the impact of the sanctions on court officials is so wide-ranging, imagine it's even worse for the Palestinian civil society organizations that have been hit by the sanctions. To talk about this issue, we are lucky to have with us Ahmed Aboufol, a Palestinian-Dutch international lawyer and legal advisor at Al-Haq. Born and raised in Gaza, Ahmed came to the Netherlands, did his master's degree at Leiden, and quickly established himself as a staunch defender of Palestinian rights. Ahmed, the floor is yours.
Thank you very much. Ladies and gentlemen, friends and colleagues, allow me to start by thanking the Rights Forum for convening this important event at this moment when the whole international legal order is under such a strain. We believe that gatherings like this are not just an academic luxury. They are moments of reflection and acts of solidarity. It is a privilege for me to address you today on behalf of Al-Haq, the oldest human rights organization in Palestine and the whole region. We were established in 1979 by a group of Palestinian lawyers who believed that the law applied equally and in a principled way was the proper answer to the occupation. For nearly 5 decades, we have documented violations by all actors without fear or favor. We documented a wide range of violations, including unlawful killings, settler pogroms, home demolitions, forced displacement, the entrenchment of the illegal colonial settlements enterprise, the structural violence of one of the longest occupations in modern history, an illegal belligerent occupation, and its settler, colonial, and apartheid regime imposed on the Palestinian people as a whole. This documentation is not a bureaucratic exercise. It is the evidentiary backbone of accountability. And the reason our engagement with the International Criminal Court has been principled and transparent for over a decade. We have filed several Article 15 communications, including legal analysis, factual files, and made submissions before the pre-trial chamber, first during the preliminary examination, and now continuing during the investigation. In Palestine, civil society is not an accessory to international justice, but it is indeed its lifeline. The court cannot operate freely on the ground in Palestine. Israel does not cooperate. It bars investigators from entering the territory. It bars UN commissions from entering the territory. And as a result, evidence is always at risk of destruction. Victims face intimidation. And in that situation, in that vacuum, Palestinian organizations have become the indispensable bridge between the court and its implementation of its mandate and the reality on the ground. And this is precisely because of the role that we have played that we have been targeted. The lesson of the last decade is an extremely disturbing one for us. The problem for the powerful, for the oppressor, was never the crimes that we documented. but it was actually the act of documentation itself. So they came after those who documented the crimes. These sanctions are not an isolated act. They are a culmination of a decade-long campaign to silence Palestinian civil society. And regrettably, much of that campaign has unfolded right here in this city, on Dutch soil. In 2016, Al-Haq and partners have urged the ICC to investigate crimes committed in Palestine. Our representative in The Hague, Nada Swanson, a lawyer working legally and lawfully in this country, the host state, and working with the court, was subjected to a sustained campaign of intimidation, death threats by phone and email, a bouquet of flowers at her home with a threatening message, thousands of fake flyers bearing Al-Haq's logo in her neighborhood. Her family abroad was even contacted and told that she will be, quote unquote, eliminated if she didn't stop. The threats also named our General Director, Shawan Jabarin. This is back in 2016. This was serious enough that even the Dutch authority, with all their bureaucracy and slowness, opened an investigation. And as a matter of fact, the ICC's own Office of the Prosecutor, under the leadership of Madame Bensouda, recorded these attacks in the 2016 report on the activities on the Birmingham examination activities, which is available online. You can read the reporting of the court on these events. And that report noted that the court had also liaised with the Dutch authorities as the host state. And what was the outcome? No one was ever held accountable. What we were told, that these were not the acts of individuals or groups. Those were the acts of state, without being able to name the state. I bet a lot of people in this room could have a fair guess. The intimidation of human rights defenders in the host state of the ICC was permitted to pass into silence. That was the first lesson that the powerful has learned, and learned it well, that you can attack those who cooperate with this court and pay no price. Then in October 2021, the Israeli Minister of Defense designated Al-Haq alongside other 5 Palestinian organizations as, quote-unquote, terrorist organizations on the so-called secret evidence. This is the oldest trick in the colonial playbook. When you cannot refute what your critics are saying, you criminalize who they are. But this time, the evidence was examined and rejected by Israel's own allies. Several EU states declared that they have received nothing to justify a change in their policy. The European Commission back then and its own anti-fraud office investigated and closed the file. It has even been reported that a CIA investigation, which was leaked to the press, has concluded that there was no justification for Israel's designations, to our surprise, of course. The accusation collapsed back then under the scrutiny of those who are most inclined to believe it. This should tell you a lot about the seriousness of Israel's allegations and the audacity of the lies that Israel has been lying for decades. And yet, in August 2022, less than a year after that day, at 3 in the morning, the Israeli forces stormed our offices in Ramallah. They seized files, they welded our front door shut with an iron plate, and posted a military order declaring us unlawful. We know what happened inside when they stormed the offices. Our forensic architecture unit reconstructed what happened from CCTV footage. While some soldiers searched our documents and files, others stood around taking trophy photos and group selfies inside our office. This is way before the genocide. Mind you, it's the same attitude. They came to a place that investigates their atrocity crimes, and they posed for selfies. Hold that image. It is the very face of impunity. And each time, the ward answered with nothing more than concern. That impunity grew bolder and bolder. Which brings us to the US sanctions. Last September, the US designated Al-Haq, Al-Mizan, and the Palestinian Center for Human Rights under its executive order entitled, literally, Imposing Sanctions on the International Criminal Court. It is the same order used against the prosecutor, 2 deputy prosecutors, 11 judges, and the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territory, Ms. Francesca Albanese. Our stated offense and crime that we had, and I quote, directly engaged in efforts by the ICC to investigate, arrest, detain, or prosecute Israeli nationals without Israel's consent. Hear that again. We were sanctioned for cooperating with a court of law for doing precisely what the Rome Statute system depends on us to do. Let me be clear. These are not just merely administrative measures. These sanctions are political weapons designed to obstruct accountability, intimidate civil society, and shield perpetrators of international crimes. As we said the day it happened, while the US backed a genocide in Gaza, and that genocide was entering its 3rd year, the US, rather than ending its complicity, chose instead to punish the very organizations documenting that genocide. And the impact has been devastating. All of our bank accounts were closed, frozen, paralyzing our operations and our ability to pay salaries to around 50 families, the number of our staff. Colleagues with US citizenship were forced to step down immediately as they would face severe criminal and civil penalties under US law. Funding streams collapsed. US partners severed corporations, and the US service providers shut us down. YouTube deleted our channel, which contained thousands of videos and witness testimonies and forensic architecture investigations, a record of history of the crimes that have been committed against the Palestinian people. MailChimp blocked our communication, a platform we used to disseminate our work and amplify our reporting. Meta restricted our outreach and our ability to use advertisements. This is not collateral damage that we're talking about here. This is the intended effect to silence Palestinian voices, to disturb the flow of evidence, and to weaken the court's ability to act. But here is what should frighten us all. It is not what has been done to those of us already named or sanctioned. As Palestinians, we have endured threats, raids, designations, and now sanctions. And we haven't stopped, and we will never stop. The real danger is the chilling effect on everyone else. As the ICC judge, Nicholas Gillou, put it, he said the greatest risk is not to those already sanctioned, but to the hundreds who will not take the decisions they need to take. because they are afraid. When the researcher stops documenting, or the lawyer stops filing, or a banker or a witness quietly steps back, justice does not collapse with a bang. It dies of silence. And this is the point I most need you to carry out of this room. This is not about Palestine. Palestine has always been the litmus test for international law. We know that. But if this court fails, if this court can be bullied into paralysis here, it can be bullied anywhere else. If documenting genocide can be made a crime here, accountability is literally finished anywhere else. The same court, the same prosecutors serve victims in many other situations, including Ukraine, Sudan, DRC, Libya. The message is to every human rights defenders in the world, and it is plain and simple. If you do this work, we will come for you. As a matter of fact, a similar phrase was used by a US lawmaker threatening the current prosecutor. Yes, they're coming for Palestinians now, but they will not stop there. Silence here is not neutrality, is not wisdom or diplomacy, as the title of this event rightly stipulates. It is cowardice and complicity. So I turn to the host state and to this country's parliamentarians in particular, because you are not bystanders. You hold the instrument that could be used with this government. The Netherlands didn't stumble into hosting this court. It actually campaigned for that role and built a whole national identity on it. The Hague, the city of peace and justice. This is not a slogan. This comes with a set of binding obligations on the Netherlands. As a host state, it must safeguard the court's ability to function, and it must ensure its independence. And under the Netherlands' human rights obligations, on your own territory, reinforced by the Assembly State Party's call to protect all those cooperating with the court, the Netherlands have a positive duty to shield them from intimidation. Not only the court and its officials, but also civil society actors working and cooperating with the court. The Netherlands owed that back in 2016 to my predecessor. It owes it to all of us today. I will continue to owe it if it wants to live to its obligations. So far, the response has been one word: regret. Each new wave of sanctions is met with a statement of regret and no action. As although an assault on a court you host were a spell of bad weather, but there has been, in all fairness, principled actions in your parliament, adopting a motion, calling for concrete national measures and EU actions, explicitly urging the government to push for the blocking statute activation and to defend the court's independence. And the cabinet's answer, correct me if I'm mistaken, was always the same, that the minister is continuously in talks about it. The motion adopted, that is good. But if it was just left to wither, then it's not worth the paper it's printed on. So my appeal is direct. Do not let your own motion die of neglect. Here is what we ask of the Netherlands and of all state parties. Concretely, they should publicly reaffirm support for the court's independence, including the situation in Palestine, and condemn condemn, not regret, condemn these sanctions officially and unambiguously as an internationally wrongful act. Once again, not just regret or express concern, condemn. The Netherlands is a sovereign state. If your sovereignty should mean anything, you should be able to utter the word condemn when you're attacked. Second, the Netherlands should lead, not to hide behind Brussels, lead the call to add the US executive order and the US sanctions to the annex of the EU Blocking Statute. So these sanctions can have no effect on European soil. We drafted this remedy and handed it to the EU and to the Dutch government. And as it seems from what's reported, it was left to Spain and Slovenia to carry it to Brussels. The host state of the court should have been first, not absent, should have been leading this effort. Third, the Netherlands should ensure that the operational continuity of the work of Palestinian human rights organizations by building, but not only the organization, but also the court itself, by building alternative banking and payment channels, safeguarding fundings and reducing dependence on US technology, now weaponized against the court. So that no judge wakes up one day and finds that their account is frozen in the host state. As Judge Posa puts it, with nothing I can do about it. The Netherlands should also protect the safety of those who cooperate with the court, especially on its territory, and counter the smear campaigns that delegitimize human rights defenders and distort the work of the court. Let me close by this. For nearly 5 years at Al-Haq, we clung to the law. We cooperated with the court, we submitted evidence, we named the crimes, provided legal analysis. We have done this through threats, raids, designations, intimidation, and even an active genocide in Gaza, and now sanctions. We have already answered, we believe, whether we are brave enough to bring these cases and to advance the cause of justice. We answered it with our sweat and blood. The only open question is whether the Netherlands and Europe, beacon of democracy and human rights, are brave enough to protect the law they claim to champion. Because make no mistake, the predators are not testing whether they can break the Palestinians. They know too well that they cannot break us. They are testing whether they can break you, your courts, your system, your treaties, your democratic safeguards, your constitutional rights that unfortunately certain European governments are actually undermining in the shameful service of an apartheid regime. Freedom of expression, freedom of assembly. People are being oppressed here in their own countries, Dutch people, in the service of an apartheid regime. They are testing whether the so-called rules-based order has any rules left or only press releases of regret and concern. Indeed, the credibility of the international system is not measured by rhetoric or statement, as Madam former prosecutor indicated. It is measured by concrete action. Al-Haq's work has always been rooted in a simple belief that international law must serve all people equally. That belief is shared by all people of conscience in this world. But the belief and the ideal alone is not enough. It must be matched by principled action and continuing efforts to push our governments to do the right thing. The road to accountability is long. It's a marathon. It was never a sprint. It is difficult and often contested. We've always understood that. But it is a road that we must walk with clarity, dedication, and conviction. Because if the law dies in The Hague, it does not die for Palestinians alone. It dies for everyone. And history will record and will never forget who stood up principally and who merely expressed concern, regret, and looked the other way. Thank you.
Thank you, Ahmed. I will refrain from addressing most of the issues that you've brought up. I think MP Kroger will have that task. I just want to very quickly come back to something you said about the sanctions, the closing of the account as an attempt to silence Palestinian civil society organizations. And I agree with you, but when I look at things in context, actually, to me, it all fits into a pattern of erasure rather than silencing. We erase the people, we erase your cultural heritage, we erase the land, your homes, and now we destroy the work that you've done for decades in documenting crimes committed by the Israelis. I don't know how you see things.
Yeah, I think they go hand in hand. The main objective of a settler colonial project is erasure. So the very existence of the Palestinian is a threat to Israel's regime, whether they're in Gaza, the West Bank, or elsewhere. But the attack on civil society is because we create a record of history, not only for courts. We're archiving what's happening to the Palestinian people since the moment we were created, but also analysis starting from 1948. We're telling the world a Palestinian narrative that the world is not used to listen. The problem, I think, in our context, that the world has often heard about the Palestinians, but almost never from them. It's always through the lens of our oppressor. And as any settler colonial regime, we're always viewed through that lens, and it's stereotype as, uncivilized. Well, you cannot reach a compromise with. We don't miss an opportunity to miss an opportunity. So the moment you have a Palestinian civil society, which has always existed, it's important to understand Palestinian civil society is older than the Palestinian national project as a whole. As a matter of fact, it's older than Israel itself. Palestinians had women rights organizations in Palestine before women could even vote in certain European countries. So it's very rooted in the reality about the Palestinian people. And I think nothing is more threatening to a settler colonial project than the indigenous people being able to articulate what they stand for, what they believe in, and be able to address the world. And I believe that's what we do. And our documentation is part of a record of history preserving our narrative. And Israel doesn't like it. For obvious reasons.
Thanks. Now we shift to a political perspective on the Netherlands' responsibility and the prospects for action. We have with us MP Suzanne Kroger, who has been a member of parliament since 2017 with GroenLinks PvdA and now Progressive Nederland. As you know, you may know, MP Kati Piri was supposed to be with us tonight, but she had to attend a parliamentary debate on the normalization of violence in politics and society. So very good reason not to be here tonight. And Madam, you have the floor.
Thank you. Thank you, and it's an incredible honor, and it also feels like a great responsibility to speak after these two incredible speakers, who also really shared their personal stories and their personal courage on a topic that's so fundamental and so vital today. And I don't think we can underestimate how incredibly important it is today to stand up for global justice. And if we talk about the ICC, today, of course, we speak a lot about it in the context of Palestine and the cases that are being prepared and put forward. But it's those institutions that keep our global rules-based order in place, and it's under severe threat, and we all realize that. At least I assume that everybody who is in this room and comes to an evening like this realizes it. But it's every day. I see it every day in Parliament. I see it slowly sliding. The democratic backslide is happening. It's terrifying. It's an attack on free speech. It's an attack on the media. It's an attack on civil society, and it's an attack on our juridical system. And even yesterday, we had a session in Parliament speaking about sexual violence as a weapon in Sudan, what's happening right now, and listening to the stories of the special rapporteur from Sudan calling into Parliament and sharing their findings, but also sharing the importance of people, of perpetrators, of being held to account, that only justice can prevail, only a society can move on if justice is being served. And so the International Criminal Court, to me, is such a fundamental basis of our international order and of any steps we can take towards a world that's, well, I think you mentioned it as in your last words, and the importance of a world where we have justice, where we have equality, or where we would have peace. And I think, it was mentioned already that the Netherlands is very proud of the International Criminal Court. It's part of an identity, it's part of a narrative, it's part of, well, something that's really important to, I think, to a lot of people. But with that importance also comes responsibility. It can't just be the one. It can't just be something that you're proud of, that you host it, that you're the host country, that The Hague is the city of justice. It comes with responsibility, and I think that's exactly where at the moment we are really at a critical point where we really need to see the Netherlands as a host country lead. And it's clear that we're not doing that. And I think that's clear from a number of inactions that have been taken, but I think the most important at the moment is putting both the political pressure and the institutional pressure, but also, as it was beautifully mentioned, the operational solidarity with anybody working or supporting or being part of the International Criminal Court system. And the Dutch Parliament has moved forward these motions of getting the blocking statute being triggered. It's important that it was supported by Parliament, and I don't know how many of you follow Dutch politics, but it's quite difficult sometimes to get things that are a little bit stronger pushed through Parliament. We've been pushing through a lot of different motions to at least see stronger sanctions on Israel, or to see more support for civil society, or condemn human rights abuses. So it's often quite difficult to form a political majority in this, unfortunate in this time. But on this topic, there was a majority, not once, but twice, of a majority of the Parliament saying, no, we really need to move forward with this blocking statute. And so far, the Dutch government has been very hesitant to do so. It's waiting, or it's saying it's preparing things, or things are being discussed, but at least it's not taking the strong stance that we need to see. And I really agree with anybody who has said, this is really a moment as a host country to lead. I think that's the fundamental notion that we should have for tonight. And yesterday, my colleague Kati Piri, who unfortunately couldn't be here today, she basically asked the minister, isn't there any shame in the fact that it's Spain, that it's Belgium, that it's others taking the lead and not the Netherlands? And again, if we're proud of the ICC, we should take that pride and also take the responsibility that comes with it. And that means putting political pressure, and that means moving forward within the EU with the blocking statute. Then on the issue, I think the impacts that these sanctions have had, not only on the ICC and therefore on global justice, but also on Palestinian civil society. And I really, I'm a spokesperson on development aid and trade, and there's really strong budget cuts happening, targeting also civil society, and you really see shrinking civic space in a lot of different countries, but especially in the context of Palestine, we need to really support civil society. It's critical, and I think the words you mentioned of the need to share history, to share, to register everything that's happening through civil society is so incredibly critical. And I'm really appalled with the fact that civil society is continuously being criminalized. NGOs are being criminalized. Palestinian NGOs are being criminalized, but also Dutch NGOs are being criminalized. They're being, how do you say, in the public debate, it's really an attack, I think, on civil society happening that's really undermining our democratic values. And I'm really, really concerned with that. I mean, I've seen it also in the Dutch parliament, the whole debate around UNRWA and about how humanitarian support to Palestine is being criminalized. So I think that for me is that this debate we're having tonight, it's on the one hand, it's about global justice, it's about holding a rules-based order in place and doing everything we can because we're in the midst of such an incredible democratic backslide. And on the other hand, it's really about Palestinian civil society and doing what we can as the Netherlands to take that responsibility and support that. So we will continue to push for strong language and strong action in the Netherlands. Yesterday we saw a bit of strong language. It was because 6 Dutch nationals were illegally detained on international waters by Israel. Then we saw language that I thought, okay, that language, we need that, and then 10 times or 100 times stronger to support and to really stand for the ICC and for Palestinian civil society. Thank you.
Thank you very much. Very briefly, obviously the Netherlands hosts many international organizations, not just the International Criminal Court, and you've acknowledged that the Netherlands should do more to protect the court. But I want to take you back to what the Netherlands has done when another international organization, the OPCW, the Organization for the Prohibition of Chemical Weapons, came under attack and threats and intimidation and spying by Russian officials. And that time there seemed to be a stronger response. So how would you explain these double standards? I have no other words to describe them.
Yeah, well, I think you can't explain it otherwise than double standards. And that's, unfortunately, I think what we see across the board when you look at what's happening, what Israel's doing, how the US is acting. There is concern, there is fear to speak out. There's fear for retaliation, I imagine, from the US. But we can't be bullied. And in the end, I think bullying is exactly the right word. And especially as the host country, we really need to stand up for what's happening and calling out these sanctions for what they are. because otherwise it's such a slippery slope. What's next? Whether it's the whole, the institutional sanctions, whether it's other institutions. I mean, we see the attack on a completely different topic. I mean, I work a lot on climate. You see the attack on the academics and the way that's being cut down and being harassed. It's all part of this big democratic backslide that we really need to speak out on.
Yeah. And on the institutional sanctions, which are now not such a remote possibility, especially with the rumors or the leaks that have emerged in very recent days about potentially new arrest warrants against Israeli officials. How will the Netherlands respond? Like, what position will the Netherlands take if indeed the court is hit by court-wide sanctions? Will you stand up to the bully this time?
Well, that's for sure what we will be pushing for. And I can't imagine that wouldn't be a moment to really, trigger, invoke the blocking statute, do all the things that need to be done, but we shouldn't let it come to that point. We really shouldn't. And I think with everything that we heard today and with everything that we know, we have all the reasons to take action. And like I said, it's Belgium, it's Spain, it's taking the lead on this, and it should be us as a host country to do so.
Yeah. And Madam Prosecutor, if indeed the court is hit by institutional sanctions, what would be the impact on the court, but not so much the court as an institution? You've already talked about the steps that can be taken, but what about the victims of the crimes that are being investigated and prosecuted?
As I mentioned in the remarks, I said when the court is hit by institutional sanctions, the consequences will be very severe. Because you first of all, you'll find that all these institutions and service providers, etc., will probably not serve the court anymore. And maybe one of the first things that the court has to do or prepare for in case this happens is to see what are the alternatives, where do we go. But again, for the victims, it means slower justice, if justice at all, because it can really derail the course that the court has taken. It can slow down, to a very large extent, the investigations into these crimes, and consequently also the prosecution of these crimes. Holding anybody accountable for the crimes, even derailing, if prosecution does happen, it can derail, because we have seen something like this happen with the Kenya cases. You saw the evidence in the end became completely eroded. Those who already had given their evidence to the court decided to withdraw their evidence to the court. And the first case, you remember, I had to withdraw because I did not, as a responsible prosecutor, I did not feel I could go ahead with that particular case. And in the second case also, largely because of witness interference and non-cooperation, the case could not go on. So these have a direct impact and consequences on the victims who have been waiting so patiently. Because it comes to a point that victims can only look to the court as the last beacon of hope. Because these conflicts happen in situations where they have lost complete trust in the system, where the system actually decides not to work, where the system decides not to investigate or decides not to prosecute. This is the context in which you find the victim. And what they do is they look up to the court that, yes, this is hope, this is where we can get justice. And if that institution is derailed or in some way affected by not investigating and prosecuting properly, the impact goes directly to the victims.
Absolutely. Ahmed, we've seen that some organizations, including the court itself or bigger NGOs, are taking some steps to limit their dependency on US service providers in this time. But it seems to me that none of these solutions so far has included the Palestinian civil society organizations that have been targeted in connection with their work and accountability in support of the court. Seems to me that you've been pretty much left to your own devices.
Yeah, I think you're pretty much accurate in that description. I mean, this is the challenge in the relationship between civil society and the court. While the court depends profoundly on civil society, especially in situations to which it does not have access, it does not utilize certain aspects of its own framework to provide protection to civil society. So in many ways, even in normal circumstances, the relationship has been a little bit extractivist in a way. But for civil society, it's the message we carry. We want the voices of victims to reach the court. Now, I have to be fair. It's not only the responsibility of the court, because in all honesty, the court cannot protect itself. It's the responsibility of state parties that created the court, that they have to ensure that there is a whole digital ecosystem that doesn't rely on US providers, because if it hasn't been clear before, I think now it's clear to the US's closest allies that it's not a reliable ally. And we start seeing that in other situations. You have France, for example, switching completely from Microsoft to, I forgot the exact name, to Linux, I think, to another operating system. Because we live in a reality where the empire takes a different form. One company can shut down a whole government. With all due respect to your whole government, if Microsoft shut the Netherlands, it can't shut it down. I know it may seem shocking, but this is the reality we live in. If Microsoft decides to shut down the Netherlands, it can't do it. And I think we start seeing more in Europe this realization that the US is not a reliable ally, and the only interest of the US is not the international legal system nor its own allies. And therefore, I think it is about time that European countries start working on their own digital environment that is GDPR compliant, let's say, and extend that net that it must weave for the court, not only in terms of technologies, but also banking system and many other services. And while weaving this net of safety and protection, it must this time be extended to civil society. I think states should not lose sight of that, because what is the point of you protect the court and make sure its operation continues, but the very actor that feeds it with documentation is left to suffer alone and will not be able to provide that information. And I think, just for everyone listening to me, I think this is this is the crux of the matter when you want to see if there is genuine political will to save the court or international justice as a whole, if civil society is extended and included in such protection measures or not. Unfortunately, up until that moment, I don't think states have lived up to that expectations, which is very unfortunate.
I agree. MP Kroger, speaking about the responsibility of the Netherlands, of course, there's the responsibility as the host state to protect the court, as well as all the other international organizations. But there's another important responsibility that we haven't talked about, but I cannot let it slide, and it's the obligation to prevent genocide and the obligation to not just respect, but ensure respect for international humanitarian law, the law of armed conflict. What is the Netherlands doing in that respect? And it's not just a moral obligation. I'm talking about legal responsibility under the Genocide Convention and under the Geneva Conventions. Are you cutting ties with Israel to begin with?
Well, again, and I feel a little bit... Again, this is something that we've been very strongly pushing for in Parliament, and also have managed to get a majority of Parliament to speak out, for example, on the, oh, now I have the Dutch word, associatieverdrag, the EU Association Treaty.
Association Agreement.
Yes. With Israel. So, yeah, the Dutch minister is going to the big meeting in Brussels, I believe, well, very soon. And again, with the parliament saying you need to ensure that you need to raise this and you need to push for these types of measures. But it's slow, it's frustrating. And I think also it's been, I mean, we're moving a bit into a better space, I would say, because, well, the last government, of course, was yeah, well, that was the last government. And we now have this minority government that's, you know, needs to either get support from us as the progressives or lean on the radical right for support. And you see that this topic really puts them in a difficult position. And I think the fact that we have managed to get a motion forward to at least get a majority of Parliament to say, no, these steps need to be taken in Europe is important, it's significant, but of course, it's not enough. It's enough when the pressure is really on. And again, I mean, I was happy yesterday that in the end, the Dutch Prime Minister spoke out about the illegal capture of the flotilla and the treatment of the Dutch citizens. But, I mean, people in Gaza are treated.
Yeah.
I mean, so again, the discrepancy is huge. And
absolutely. Yeah. That's, I mean, routine treatment for Palestinian prisoners, huh? Not just and Palestinians in
much
Gaza.
Worse.
Absolutely, yes. So looking at the time and sort of trying to wrap up, because we ran massively over time, it seems to me that what is really at stake here is more than protecting the International Criminal Court as an institution or individual judges or court officials, but it's really about protecting the rule of law. And as we said before, an interference with the administration of justice is a serious attack to the rule of law, Madam Prosecutor. And the approach that states seem to have taken is to treat this as a very bad storm that somehow we have to weather. You know, let's brace ourselves and it'll pass. And I would argue, actually, it's a disease. And it will spread rapidly unless effective measures are taken, and we need to do that now. I wonder if you have any reflections on this.
I couldn't put it better. Really. This is what we have seen happening. The court was established to deal with these heinous crimes: war crimes, crimes against humanity, genocide, crime of aggression. And these are crimes that we have all agreed they shock the conscience of humanity. It shouldn't happen. We have to find a way to deal with it, to bring accountability, to bring justice. And this is the institution today that represents that fight. And if the attempt is to kill that institution or make sure that it, just slips into oblivion, then a lot is left to be done. Simply put, the crimes will not be addressed, it will not be investigated, it will not be prosecuted. And the fact that sanctions are being made, as we know, bullying tactics to silence people, to stop investigations from happening, should have the effect of giving us more will to carry on. It should not have the impact that is needed, that is wanted. Those who are giving the sanctions want that the court doesn't exist, these crimes will not be investigated, and that's the end of it. We should have the opposite will to make sure that we come together again, we resolve, we recommit We have new resolve and know that if we allow this to happen, it will not be only to the International Criminal Court. The whole international justice system will be at stake. And the rule of law, forget about it.
Yes, absolutely. And I know that we all know that the threats, the intimidation, the sanctions didn't make you change your mind. You continued, you carried on, you did your work, you opened an investigation in the situation in the state of Palestine. I wonder, were you ever scared? Did you have second thoughts? Did you ever think about quitting at any point?
No. Quitting, never. When I am asked now whether I thought about quitting, it's the first time really I'm thinking that, people were even thinking I should quit. But it never really crossed my mind. As far as I'm concerned, I was elected into the position with all trust and confidence in what I was able to bring to the table. I took an oath to do my work. I believe I had the integrity to do that work. And if there are if there are threats and sanctions to stop me from doing that work, and I cave in, then there was no point in electing me to the position. Really, there was no point. So for me, it's just to continue. Do my work at great personal risk, also of those who supported me. But the idea was never to give in. I never thought about that, really. Never.
Yeah, nor should anyone. Okay, on that very strong message, I think it's appropriate to bring this discussion to an end. I want to thank again our panelists for sharing their thoughts and their views and doing so openly. Please, again, I think they deserve another round of applause. Again, thanks to the organizing for this event and the donors that made it possible. If you want to support the Rights Forum in organizing more events like this, you are welcome to contribute. You will find a QR code with a link to donations on the flyer on your chair. And I think it's important to not leave this room with a sense of frustration, but with a sense of purpose. So one of the things that you can do is to sign an open petition of the Rights Forum to protect the International Criminal Court. It will be very important to do so. I'm sorry we didn't have time for questions from the audience. We were running a bit late, but I'm happy to say that we can continue this discussion over drinks at the bar just outside this room. Thanks again for coming tonight.